Thank you all for coming. This is a special seminar for a special guest who is at CSAT at CDRL. It's hard to get that out of me, being here on the second floor. A guest at CDRL for this quarter, Ned Foley. Ned is actually going to be giving a regular research seminar on what he's doing right now in a few weeks, towards the end of February. But he's got a brand new book out, and this is a celebration of that book. So the seminar will not be as formal as our other Thursday seminars. We want to make it more of a conversation, so I'm going to be prompting some questions to Ned and to Bruce Kane, who has agreed to be a discussant here. This book is out there. There's a representative from the bookstore out there, and I would recommend getting this book. And I don't know why it took so long for a book to be written on this subject. It's Ballot Battles, a history of disputed elections in the United States, taking us all the way from the founding up until today. And it really is a great book. It really is terrific. At the intersection of history, law, political science, democracy, all the things that we care about. So what was the inspiration for this book?
Well, first of all, thank you so much for having me here at Stanford this quarter. I wish I were staying longer. Don't tell my family back in Ohio that, but I'm having a blast. I'm really having a great time. And thanks also, for this extra session for today. So I am a law professor, and originally I wasn't going to write a history book. I had gotten a grant from a foundation to study best practices of recount laws, to think of what would be the most sensible way or model rules to do a recount properly for the future. And as a result of trying to do that work, I came to the conclusion that really the only way to understand this topic is to understand it historically. And Bruce has heard me say this, but the law professor in me says the most recent precedent that's relevant is the most important one. You only go back in time as far back as you need to. So if the best precedent was 10 years ago, you don't go back 20 years. That's how we write our legal briefs. But for this project, I kept going back and back and back all the way to the founding because of the belief that the inadequacy of our institutions to handle these disputes is a result of choices made and omissions made at the time of the founding, and how they conceived of elections and ballot counting. And so the reason why Florida 2000 was so chaotic, and the reason why we may have another chaos at some point in the future is really, in my view, a result of deficiencies that existed at the time of the founding.
So when, several years ago, I directed a global commission on elections, on the integrity of how best to promote and protect the integrity of elections. And that commission was very critical of the United States, the integrity of American elections. And one of the issues that we grappled with was the importance of having professional, independent, impartial election management bodies, of which for the most part they don't exist in this country. Although it's best practice everywhere else, it doesn't exist here. And when we came out with our report, a friend of mine at the UN, who actually was head of the UN elections branch, sent me an email congratulating us on the report, saying this is a terrific report about the integrity of elections. Now, if you could only figure out what is the relationship between the integrity of elections and democratic legitimacy, then you really will have discovered something. And reading your book, it strikes me that that's exactly what you're getting at, because as you use this framing device right from the beginning, that Madison and Hamilton had very different ideas about how you deal with disputed elections, really bad elections, right? Can you talk about that some?
Sure. And it is true that when the founders confronted this problem, they didn't exactly know how to react to it, and they reacted differently in terms of their different individual personalities. And Madison was more of the type that wanted to get each election right. He sort of thought that there was an integrity to the voting process each time, and that there ought to be a winner and loser determined by the rule of law and an accurate count of the ballots. So that's sort of the Madisonian vision, as I call it. Hamilton, the pragmatist, was less concerned that each election turn out okay. He was more concerned that the polity over the course of decades was systematically fair. So his attitude was, if there was a really close vote in a particular election, and that election is stolen or rigged, or the result is somehow delegitimate in the one instance, Hamilton's attitude was brush it off, run the next time, and it's only if election after election after election they're rigged and stolen, no matter how close the outcome. So in other words, if you can steal an election when the spread between the candidates is huge, then you know you've got failure to the system. But if you can come back and win the next time, even if it was stolen from you the first time, Hamilton could sort of live with that. Whereas Madison wanted to get each and every election right on its own merits.
So one of the first elections that you discuss in the book is the 1792 gubernatorial election. Can you go into a little detail, use that as a case for laying out some of the sort of themes that are in the book that you keep coming back to? Sure.
And this was one of the early elections that shows the founders kind of struggling and trying to figure out what to do. And there we have John Jay and George Clinton. These are the two candidates in New York in 1792. And political parties are already forming. Again, Jay was one of the authors of the Federalist Papers. They had hoped to avoid the creation of sort of permanent political parties. They thought that separation of powers as a constitutional device could keep factions in check, because there would be a multiplicity of factions and they wouldn't coalesce into opposing parties. But already by 1792, we have the Federalist Party and the Jeffersonian Party, sometimes called the Democratic Republicans or what have you, but they have a sense that there are these two teams that are forming and fighting for power. And Clinton has been the incumbent in New York for some time, and the Federalists want to knock him out. And Hamilton, again, recruits Jay to be the candidate as the challenger. Jay is the sitting Chief Justice of the United States Supreme Court, the first. And he shows the relative importance of those jobs at the time. He's willing to give up being Chief Justice of the United States in order to run for governor of New York, because that's where the real power is. And so it's a statewide election. And that's the key point, is that the country is unfamiliar with the concept of a vote counting dispute when the stakes are this high in a statewide race. They know what it's like to fight over a single seat in a legislative body. They've had elected colonial legislatures, so they've had vote counting disputes of that nature, but normally a single seat's not that big a deal. Yes, it's a big deal if you're the candidate in that race, or it's your particular vote that might not get counted, but it usually doesn't control the power of government. But the New York governor is a powerful office, has a veto. The New York governor and the Massachusetts governor are the two most powerful governors that they create in the first set of constitutions. And so this is a big deal job. New York's a big state. And it turns out that there's a dispute over ballots cast in Cooperstown, New York. The Baseball Hall of Fame wasn't there back then, obviously, but it was a nice town, William Cooper's town, actually, a Federalist enclave. And so if they count these ballots, Jay's going to win the election by about 200 votes. But they end up disqualifying the ballots, and Clinton wins re-election by 108 votes. And the body that is empowered to make that decision to disqualify the ballots was it's called a canvassing committee. It was a committee created by the New York legislature. New York had a statute that called for the creation of this committee, and it was supposed to have 12 members, 6 appointed by the New York Senate and 6 appointed by the New York Assembly, the lower house. The Senate appoints 3 Federalists and 3 Jeffersonians to be an even split between the parties. The Assembly, controlled by the Jeffersonians, the Clintonians, puts all 6 of their folks on this committee, so there's a 9-3 split, and that causes outrage among the Federalists. A guy named James Kent, who he's young at the time, he's later becomes America's Blackstone. He writes commentaries on the Constitution and so forth. He calls that the corrupt move, the partisan move to stack the body with too many partisans of one party. But that is going to be the tribunal, and they treat it, they lawyer up, just like in 2000. And the 2 senators from New York State, the U.S. senators, become like the heads of these large legal teams, lots of briefs. So you have Aaron Burr taking the lead for Clinton, and you have a guy named Rufus King, the Federalist, taking the lead for Jay. It's sort of like Warren Christopher and James Baker taking it for. It's all there at the time of the founding, and they write these briefs to both sides to try to convince the canvassing board what to do. I won't go into all of the technical details, but if I might, can I read you just a little bit of the snippets from the briefs, because I think they the flavor is similar today. So here is Rufus King arguing to count the ballots that would have Jay win. Right, the election law is intended to render effectual the constitutional right of suffrage. It should be therefore liberally construed. The existence of all representative republics is founded on the rights of suffrage. Comes from the Constitution of New York. Legislature can pass laws to guard this right, but not to destroy it. That could have been Gore's brief in 2000. The right to vote is the most important thing. We have to protect it. On the other side, Edmund Randolph, the first U.S. Attorney General, he gets recruited by Aaron Burr. He says the very sacredness of the right of suffrage exacts a degree of rigor in insisting on those rules which are designed to be the outworks of its defense. Otherwise, subtlety and refinement may by degrees reduce the security against fraud to a mere nullity. Again, James Baker or Ted Olson could have said that, for the Bush side, to say election laws exist to protect the integrity of the process. They have to be followed in advance. You can't bend the rules after the ballots count just because you're worried that somebody might have been disenfranchised. They weren't arguing about hanging chads back then. They were arguing about other features of the electoral system. But the meta principles and this competing jurisprudential debate between strict enforcement on the one hand or relaxed enforcement for the sake of avoiding disenfranchisement, that meta debate at the time of the founding. And you can see this is such a big deal that folks in Virginia are following it. So you have letters from Jefferson and Madison and Monroe all trying to figure out what's the right answer here. And again, I won't go into the details unless you want to, but you have Madison kind of scratching his head saying, follow the rules strictly or protect voters from disenfranchisement. I'm not sure. They're legitimate arguments on both sides. And that's why Kent is the one who says, the key point is the institutional point. There may be good arguments on both sides, but it's this odd formulation, right? He's trying to search for an impartial tribunal, and he's saying that it was corrupt, that this canvassing board was 9-3 against one side, and he says they ought to have been equally biased, right? Now, of course, the 6-6 split, you need a tiebreaker.
Well, that's an argument for bipartisanship, right?
Well,
that's a fundamental divide in our field between the people who like bipartisan solutions versus the people that like impartial solutions. And what he's saying, equally biased, is bipartisan solution.
The reason why the book covers from the founding to the present is I try to make a claim that we have made it's ultimately a good news story. We have improved over the course of American history. The 19th century looks quite bad in comparison to the 20th. A lot more violence, a lot more civil unrest, instability in the 19th century. That's because, on the whole, the institutions for these disputes was more partisan, more susceptible to claims that it was rigged and biased. And we've gotten better institutions, but we're still evolving. And so the question is, what is the best institution? And we can talk more about that, is one that I think does have this feature of bipartisanship, and yet with some sort of neutral tiebreaker, because you have to ultimately say either Jay won or Clinton won or Bush won or Gore won or what have you.
You mentioned violence. I mean, for all those at CDRL who study the founding of democracy and study democracy all around the world, an ongoing concern, especially in young democracies, is the relationship between elections and violence. And what comes through in this book is actually, in America's history, quite a bit of violence surrounding elections. And actually relatively, going much later than I think people realize.
Right. And when I first got into the project, I had heard about violence in Southern elections, so during Reconstruction, and about bloody Kansas before the Civil War. So I originally thought maybe this was a phenomenon sort of unique either to the South or to the problem of slavery and so forth. And there are examples of that. There's the Brooks-Baxter War in Arkansas in 1872, where lots of people die, unfortunately, over counting the votes. And the Colfax Massacre, also 1872 in Louisiana, is just horrific. But the Buckshot War of 1838 was Pennsylvania, and it was the example where the incumbent party, the Whigs, want to keep control, and they want to use their military power of the state militia to basically steal the election, and that gets ugly. And then in Maine in 1879, very similar dynamic. There, though, it's the Democrats that are the incumbent party and want to keep control. And it's only Civil War hero Joshua Chamberlain, who's in charge of the state militia at the time, who says, no, we actually have to send this to the Maine Supreme Court for an answer. And so he saves the day. But going up late, let me just show you if I can. Let me get this. So there's an assassination in Kentucky's gubernatorial election of 1899. And this is from Harper's Weekly magazine, so this gets national attention. And this is the Democratic candidate over here, William Goebel, he's shot. He's shot from there. You can see the spectators looking up to the window. Shot from the Secretary of State office. You think Catherine Harris is bad? She didn't shoot anybody. So the shots that were fired from the Republican Secretary of State's office, killing and that's post-election. That's not that is because what happens is the Democrats control the state legislature. And the Republicans think, sort of rightly, it doesn't justify assassination, but the Democrats in the legislature manipulate the count of the ballots, pretext, using their power in the legislature to kind of to rig the result. And so the Republicans are unhappy, and they take it out with violence.
And so what is the story? Do you have what is the big story of the diminution of violence in elections?
So. And this actually is a project I want to pursue in domains other than just vote counting now. But my conjecture, there's evidence of it in this book, but I think more can be done. I think the progressive era brought in a cultural transformation about the attitude of democracy, including women's suffrage. And one conjecture is that just changes the dynamic of what it means to vote, who's showing up for voting, the nature of the process. We have the Australian ballot. So many electoral reforms occurred during the progressive era. The Australian ballot as a mechanical device, that's the secret ballot where the government prints the ballot. I think that reduces the risks of vote counting problems, so that's a good thing in and of itself. But for example, Charles Evans Hughes is the New York Republican governor in 1905, and it looks like a New York City mayor's race is being stolen. It was a big deal race. William Randolph Hearst, the newspaper magnate, is running for mayor of New York. Kind of like, I guess, the Donald Trump of his era, I don't know, or maybe the Mike Bloomberg of his era. And anyway, so Hughes gets the New York legislature to say, we've got to have a law that has a fair recount. The integrity of our system depends on honest elections and a fair count. And I think that's the crystallization of a mindset that starts to take hold. And there is increase. I mean, I know I'm a lawyer, and therefore you might think of this as a discipline bias, but I do think it is accurate to say that as these disputes move into courts and are subjected to judicial process and the rule of law, that's a better forum for fighting these disputes than with guns, at the State House. And so so for example, in 1940, what happens in Missouri is the Democrats control the legislature. Again, it's just like Kentucky. They want to manipulate the results to get their guy in power. But there's no violence. Instead, the Missouri Supreme Court, also happened to be controlled by Democrats, says, no. We're not going to let the legislature steal this election. We're going to subject this to the Hughes principle of an honest count. And so the cartoon of the era has and they call it the majesty of the law, the hand of the judiciary protecting the governor's office from machine politics or the manipulation of the count in the legislature. And the high water mark is 1862 in Minnesota, where we can talk about the design of that tribunal as a particularly fair one. So I think that's the best explanation that I've come up with so far about why the 20th century is not perfect by any means. For example, Rhode Island, 1956, it's decided by the state court, but there the state court is a partisan body. The governor is an incumbent Democrat. He wants to stay in power. His cronies are on the state bench. And in this I would have flunked those judges' opinion in a law school exam because it is the most outrageous manipulation of the absentee voting rules. It's just a sham pretext fig leaf. But they have the power to do it, and so they award the election to their guy. The Republicans think about going to federal court, but in 1956 you can't go to federal court. And that's a whole other story in itself, which I think is an important story that we could get into if you want to.
Maybe one or two more questions, and I want to turn to Bruce. So you include Nixon Kennedy in 1960, which on its face is not necessarily a disputed election, right? Can you say some things about that and what you found?
Sure. That actually leads into this point about the role of federal courts. So remember the Kentucky assassination. That actually goes to the U.S. Supreme Court because the Republicans, in addition, assassination is bad. We don't like that, but the Republicans think that the governorship has been stolen from them. So they go to court, and it goes all the way up to the U.S. Supreme Court. In an 8-1 decision, the U.S. Supreme Court says no jurisdiction. We can't touch these ballot counting disputes. We're powerless. Even if you bring a 14th Amendment claim, it doesn't matter. Can't do it. The sole dissenter is this guy. Anybody recognize him? John Marshall Harlan, known in the law school world as the great dissenter, because he's often the lone dissenter of his era. He was the one who wrote the dissent in Plessy versus Ferguson, the separate but equal case of the same era. He gets vindicated half century later in Brown versus Board of Education. And his dissent in this case ultimately gets vindicated too, in ways we can talk about in a second. So he says, the manipulation of ballots is a crime against free government. And there's got to be judicial power stop it. And he invokes the due process clause of the 14th Amendment. He says manipulating the vote results should be seen as a breach of due process. And so that's his view. But that's a view that is in dissent. And the consequence of him being in dissent means that if a state system is rigged, meaning the state judiciary is unfair, like the Rhode Island example, there's no resort to federal court. And that's my analysis of 1960. In other words, I don't know what the right answer was in terms of, did Daley steal Illinois for Kennedy? I don't know. I mean, we could talk about the details of that. The point is that the two states were plausibly in dispute in 1960, Illinois and Texas. Nixon would have had to prevail in both of those to be president. But there was no point in trying to fight, because even if he could have gotten a fair count in Illinois, he didn't have a chance of getting a fair count in Texas, because the Texas system was without question under Democratic control, under Lyndon Johnson's, Johnson was on the ticket for Kennedy. And so Nixon says, we can't go to federal court, no point trying to go to state court, so he took the Hamiltonian view. I'll concede this election even if it was stolen from me, and I'll come back and fight again, and obviously does win in 1968. He's a pragmatic politician in the Hamiltonian vein. But I think, again, regardless of party, regardless of what the right answer was from a Madisonian perspective, of what an accurate count would have achieved, I think we have to think of 1960 as a failure of our system because there wasn't that process in place to give a candidate and the voters a fair count. In other words, Nixon had to walk away from, in other words, if you take the Madisonian view, this was a failure because you couldn't test the legitimacy of that particular election.
So the big election in our time in 2000, what did you find and how did you treat it?
So Bush versus Gore is the decision that vindicates Harlan's dissent. Right? The Supreme Court in Bush versus Gore does a 180 on the jurisprudence of that Kentucky case. Right? 8-1, the Supreme Court says we don't touch these cases, can't bring a 14th Amendment claim, we have no role. Right? The U.S. Supreme Court in Bush versus Gore, by a 7-2 vote, says the 14th Amendment does exist to stop ballot counting manipulation by state institutions, by either a Florida Secretary of State or a Florida Supreme Court or whatever. There's two parts to Bush versus Gore. The first part is the equal protection ruling, again 7-2, getting Justice Breyer and Justice Souter, along with the 5 in the majority, to agree that there are these valid 14th Amendment claims. And that's what Harlan was saying. They split 5-4 on the consequence of that, and of course the court stops the recount. And if I can jump ahead, so this is the conception of the majority opinion, right? It's just politicians in robes, but underneath their black robes, they're just, you can see this is like GOP partisan hacks, right? And so I think we have to have a nuanced view of Bush versus Gore. We have to say that the first part of the case, vindicating the Harlan position, is probably a force for good in the evolutionary story of 200 years going into the future. My projection is in the 21st century, the fact that you can invoke the 14th Amendment to stop ballot counting manipulation will be used by lower federal courts to prevent shenanigans from happening in local races and things that don't deserve the Supreme Court's attention. And by and large, I think the federal judiciary will do a better job than state legislatures or state courts in being more impartial, more fair. But in the high stakes cases, judges are human, and so the question is, can we come up with a better institution than the conventional U.S. Supreme Court in a presidential election or when the stakes are really high. And so we ran an experiment in 2008 modeled on the success story I told you about, the Minnesota example of 1962. And this goes to Bruce's question about how to structure this. So what we did a hypothetical case based on Colorado provisional ballots. And we had Walter Dellinger argue as if he was the Democrat lawyer, and we had a guy named Glenn Nager from the prominent firm called Jones Day, who had service in the U.S. Solicitor General's office, argue for the Republicans. And it's like a little mini social science experiment. So Pat Wald had been the chief judge of the D.C. Circuit Federal Court in Washington, and a Carter appointee known as a liberal Democrat. And Tom Phillips had been the Chief Justice of the Texas Supreme Court, known as a conservative Republican. We kind of picked those two to anchor this panel and said, you pick the third judge, whoever you want. We won't have influenced you in any way, shape, or form. And they picked this guy, David Levy, the dean of the Duke Law School, who had been a former federal judge, as someone that they thought was genuinely fair-minded and neutral. And they actually went through they put on their robes. We did this at Georgetown. We videotaped it. They actually issued an opinion for us. It turned out to be unanimous, which was interesting. And for all the work that I've done, it seems to me that's your best chance at a fair institution. They're one from one side, one. So the Democrats see we've got our person on the body. The Republicans see we've got our person on the body, and yet somebody to be neutral. So my recommendation at the end of the book is that we would probably be better off if we design a special purpose tribunal. It would satisfy the Kent demand for being equally biased and yet have a tiebreaker. But unless and until we invent that tribunal, we're stuck with the Supreme Court. Although we haven't talked about this and we can't. I mean, the risk going into the future is, the Supreme Court got the last word in Bush versus Gore. Why? Because Gore conceded that next day. He didn't take the fight to Congress. Next time around, the Supreme Court might not get involved. Its jurisdiction is discretionary. Or a candidate might say, I'm not stopping at the Supreme Court. I want to take my fight to Congress. And if that happens and the Senate, let's say the Senate thinks Hillary Clinton has won the election, and the House of Representatives thinks Donald Trump has won the election. And Trump thinks that, and let's say the U.S. Supreme Court doesn't get involved or whatever, we actually don't have an institution that can break a two-chamber deadlock that way. And that's the lesson from 1876, which we can talk about if you want.
Okay. Let me turn to Bruce. Bruce, you were mentioning that you knew that this book was several years in the making and that was coming. So when you finally got the manuscript, what were your reaction?
Well, when you know somebody pretty well, you hear their voice when you read the book. And so I could hear Ned's voice, and with that comes certain Ned Foley themes. And so it's a great book, and I enjoyed it. But I read it with another level of understanding because we belong to a group that meets quite regularly, the election law people. And so there are some things that are distinctive Foleyisms here that are disputed, but I think great ideas. Okay, so for example, the notion about the 14th Amendment that he talked about, the first part of Bush v. Gore, as Ned knows, OSU is, if you take a sort of continuum of law schools about how much credence and how much faith to put in the 14th Amendment out of Bush v. Gore, I would say OSU, you and Dan are kind of way over on the most optimistic end. And then there are a whole bunch of other people that are less optimistic because the Supreme Court went out of its way in that decision to cabin, and to use the word in the law, the 14th Amendment's applicability. And so he threw in a little line about lower court decisions and there are some examples on some of the new voting cases where the courts have stepped in and said it's unfair of you to bring these voting restrictions in at this time without the right review. And so I think I would like the court to be more aggressive. I'm not as sure as they are that the court will do that, precisely because it has, at the state level, so many of these people are elected and feel electoral pressures. And at the federal level, we see increasing polarization around the Supreme Court. So I'm just not sure that 14th Amendment doctrine will be expanded in the way that I completely agree with Ned. It would be good to end this. Because that gets to a point that he made earlier about the discretion. And he said there's this fundamental tension between discretion and strict reading, where you might exercise discretion to give a break to a voter. For example, a voter who didn't actually make a mistake, but the poll worker made the mistake, which is a big theme in many of the cases. So why should you take somebody's vote away if the poll worker made a mistake, or if the sheriff didn't deliver? It wasn't really a sheriff when he delivered the votes. I mean, why should the voter be stuck with that? But the problem that you have is when you give discretion in the American political system, you're putting it on top of a highly decentralized system, which allows for winner's justice. In other words, for people in each one of these settings to say, well, I think we need to be strict this time. But then if the circumstances turn around, then the party's going to say, well, I think we need to be broad this time. And we've seen that with all kinds of rules.
Or in the same election, right?
Or in the same election, yeah.
Like Leon Panetta, when he's in Congress, he starts out with a
that's
lenient...
That's a great story, actually, yeah.
Right? This is the House of... It's called the Bloody Eighth in Indiana. It's a House of Representatives race in 1984. And there's a 3-member panel, but it's got 2 Democrats and 1 Republican. Leon Panetta happens to be in Congress and chairing the panel. And they're liberal, so they can count more Democratic votes until they get enough. And then they switch the rules and decide, okay, now we're going to be strict.
And we see this over and over again. I mean, what's the view inside D.C. about the filibuster? Well, it's terrible when the Democratic Party's in control. They think it's a terrible thing, but then put them on the minority, and all of a sudden they want to change the filibuster. So it's a problem because, as Ned says early in the book, nobody really thought through these problems. Nobody anticipated then, you blame the Founding Fathers, but never mind the Founding Fathers, all of us, to really understand how partisanship could grow in this country. I think we forgot about the 19th century. We thought it was an anomaly. We left it behind. Ned's point was the Founding Fathers thought they took care of it through the careful design of factionalism, but then parties came in anyway, and they didn't. It came in pretty quickly. But then we forgot about it in the interwar period or the war period because we were all on the same team, so to speak, and various other reasons. And now and a big theme in this book, if you follow the timeline, is that the potential for disaster is always there, but the political conditions change. And so it's a big theme in this book that when you get there are periods like the 20s and 30s where there's not as much in the way of dispute, or even maybe in the 60s, as you said, with Nixon. In a different era, he might have fought that, right? And then lots of things change. Partly it's judicial doctrine, it's the political question doctrine, bringing the courts in and giving another bite of the apple if you lose. But more importantly is the polarization that I think a lot of us didn't see coming to the degree that it is now back in the 70s. There's just no way that I can't think of any political scientist, can you, Frank, that saw this coming this way. It just wasn't in our minds. Let me just say one more thing that he brought up, and that is this whole business of the tiebreaker. This is a big design question, not just with respect to ballots, but also comes up in redistricting. And what we're seeing in the commissions in redistricting makes me nervous when you think about the whole design that you have in mind, which is David Levy's position there, the neutral person. That's exactly what is going on in the Arizona case with redistricting. That is the woman who was an independent acted in ways that the Republicans are absolutely convinced were biased for the Democratic Party. And it didn't help that she's married to a Democratic activist. And it didn't help that they hired Democratic consultants. And in California, it's a little bit better because instead of having one independent, we had 5 or 6, and you had to have a majority of each one of the categories: Republicans, Democrats, and Independents. So it turned out that there was a Ned Foley hero on there. It was the former director of the census, Vince Barabas, and he turned out to be the hero on that saved that commission from going down the tubes, because he persuaded a couple more of the Republicans to go along. They could have stopped the whole thing, and the whole thing could have been a disaster. The first time Arizona ran, it went well, and the guy that ran it had a whole 10 years going around talking about how this is a good system and a good design. And then the second time Arizona ran the same thing, it blew up because partisanship took over and gaming became very important, and the Democrats figured out how to game the system. So I worry about these mechanisms, and I don't think we have a good solution. I'm a little bit more in what we call the New Jersey model, which is having somebody who's an arbitrator and tries to get the differences to be diminished. And my theory is if you can get the differences to be diminished, even if there's a slight bias in the end, it's not as much of a problem. But I don't think that's easy to do in the vote counting case. But I think to get back to Ned's major thesis, which is that this whole problem, first of all, every democracy is going to have it, but we're going to have it in spades because of our constitutional structure. When you think about the culture that we have and the politicization of our judiciary, the politicization of our administration, we've made an implicit choice for responsiveness over impartiality. We don't have the cultures, which you know very well about, of trying to socialize impartiality, which many of the OECD nations do. We don't have that in our bureaucracy. Most of the powerful positions go to people that are quite the opposite. They were loyal to a particular candidate or a particular party. So when we think about reform, it's kind of like a surgery, on a body, right? And it can be rejected by the immune system, right? And if you have a completely politicized system, which has a complete skepticism about impartial bureaucrats and I think increasingly about the judiciary, even though law schools try very hard to imbue this kind of socialization, I just think when you try to take that mechanism which works in other countries and you put it onto the body politic in America, it's going to get rejected. And so it's a much deeper problem for us, I think.
Can I?
Yeah.
No, I guess I would say that potentially redistricting, the concerns that you raise, I would submit have more purchase in the redistricting context, because that's inherently a policy judgment of some kind. Now, you might take an argument that when you have an intense vote counting dispute over, let's say, who's going to be president, that in fact, let's not decide this legalistically. Let's decide this, in other words, whether Hayes won or Tilden won, let's not try to figure out a Madisonian legal answer as to who won the most votes in an honest count. Let's just figure out whether Hayes would be better for the country or Tilden would be better for the country, or let's have a compromise and take the troops out of the South and Reconstruction, or there was a political solution as opposed to a legal solution. And in that view, resolving these disputes would look more like redistricting. But then again, the fear is if the losers to the political accommodation don't accept the legitimacy of the result, that can lead to violence and other examples. So I would at least presumptively argue that vote counting disputes should be treated differently from redistricting, and arguably call for a different institutional solution than the redistricting context, although they're relations. Ultimately, any of these institutions are going to be people by human beings, not computers, and so a degree of imperfection. There's kind of a, the holy grail or the quest, the Don Quixote quest is to, do better and better and better, and we're reaching for that, but we're never going to be perfect. So you put in place as clear, precise, defined rules ahead of time to limit discretion, because you're less likely to have a dispute if it's just absolutely clear what has to happen to the ballots and there's no maneuverability. But the story of the book is there's always going to be something that you can't take account of ahead of time. You aren't going to figure out why they dispute over these absentee ballots in this way or what have you. And then there's this relationship between the quality of the institution that's going to be the ultimate decider and the virtue or the quality of the individuals who are going to be the decision makers in whatever institutional setting they're in, whether it's a better institution or an inferior institution. So I would rather maximize the design of the institution that places less attention on individual virtue, because if you place it on individual virtue, you're more at the mercy of a bad actor making a bad decision. There's no guarantee of success, though. I think that's absolutely right.